continue eating or getting your food, as the case may be, but we're going to go ahead and get started so that we can give Professor Black the time that he needs to make his remarks. My name is Howard Sufer. I'm a partner and the head of the Education Law Group at Bowles Rice, and it's a pleasure to welcome everybody to the luncheon today. I'm here with my colleagues from Bowles Rice, Rebecca Tinder and Christy Pill-Fisher over here at this table. And it's been a wonderful conference, I think, so far. Derek Black is a professor of law at the University of South Carolina School of Law, and he's an expert in education law and policy, constitutional law, and civil rights. His research and his scholarship focuses on the constitutional and statutory rights of disadvantaged students, on school funding, and on the federal role in education. Professor Black is also a prolific author. He's written the leading education law casebook and over 25 full-length law review articles in journals such as the Stanford Law Review, California Law Review, and Cornell. His work has been cited more than 500 times, including in Supreme Court briefs and Court of Appeals decisions. Professor Black is a frequent commentator with op-eds and essays. They have appeared in outlets like the Los Angeles Times, the Chicago Tribune, Newsweek, Time, and Education Week. His Education Law Prof blog has a devoted following that generates between 35,000 and 40,000 unique visitors a year. I count myself among the most patriotic. All this work leads to frequent media requests, including various NPR outlets, the Washington Post, the Wall Street Journal. Professor Black has also served as an expert witness in federal education cases and a pending statewide school funding case. He has a book about to come out, Schoolhouse Burning, that explains how current education trends represent a retreat from our nation's fundamental commitments to democracy and public education. Prior to entering legal academia, Professor Black was an attorney with the Lawyers Committee for Civil Rights under law. He also previously served on President Obama's transition team as a U.S. Commission on Civil Rights team member. Professor Black earned his J.D. from the University of North Carolina School of Law and a B.A. from the University of Tennessee. Let's welcome Professor Black.
If I'd have known you were going to say all that, I would have stayed home, so good thing you didn't warn me. Thanks to Josh Washert for organizing this and bringing this all together to talk about education rights, to reflect on where they've been, where they're going. Thanks to all the law review members who've certainly put in a tremendous amount of work. Thanks to the College of Law for supporting it, and certainly the law firm and others, and of course you for coming out today. Certainly a pleasure to be here. If a nation expects to be ignorant and free, it expects what never was and never will be. Thomas Jefferson. 40 years ago, in 1979, the West Virginia Supreme Court was called upon to decide an issue not much unlike the issues still with us in nearly every state in the country. The issue, as the court termed it, was, quote, of inequalities in secondary education opportunity and achievement created by markedly out-of-balance funding in property-poor counties compared with more wealthy counties. After extensive analysis and thought, looking solely at the constitutional doctrine before it, the court triumphantly announced that, quote, education is a fundamental right in this state. 40 years later, it is far too easy to underappreciate that holding, far too easy to treat that language as quaint, dated, or just something that happened 40 years ago. Today, I want to ask that we take Pauli seriously. And that means taking the education clause upon which Pauli was decided seriously. That means taking the motives and conditions that led that clause to come into existence seriously. That means taking the foundational ideas and the opinion of Pauli seriously, and it means taking the current encroachment on those ideas and those principles seriously today. So maybe it's just me wanting to talk about history, which I increasingly tend to think is something that aging men and women like to do, and I'm unfortunately getting to the time where I put myself in that group. But it seems to me altogether fitting that we go back to the beginning and with the Education Clause and its history itself in the state of West Virginia. In 1861, the state of West Virginia separated from the state of Virginia in the lead up to into our nation's greatest conflict, and it immediately began working on its constitution, calling constitutional conventions first in 1862 and again later in 1872. For our purposes, of course, we want to focus on the education portion. In those constitutional convention debates and the factual circumstances surrounding them, a few things were abundantly clear. A lot of people did not have the education that they needed. They didn't have it here in West Virginia. They didn't have it in South Carolina. They didn't have it in Mississippi, Alabama, Florida. We could go down the list. They had it in some northern states, but not all. So we began, and they spoke about it here, the idea that people did not have the education they needed. The second thing was that the people who showed up at that convention wanted a constitution to cure that problem. They wanted to take the issue of education out of the hands of politicians. No offense to the governor. They wanted to take it out of the hands of changing sentiments. They wanted to take it out of the hands of regular debate, maybe even out of the reality with which they were forced to struggle on a daily basis. They wanted education to be the first priority of the state of West Virginia. Not something the state would do when it got around to it. Not something the state would do if it was convenient. Not something the state would do when the railroads were built and the roads replowed and the courthouse refurbished. No, education would be the first thing the state would do each and every year. And they wanted to do so not just because they thought it was good policy. They wanted to do it because they believed it was a necessary step in ensuring a Republican form of government and ensuring a democracy in the state of West Virginia. It was a sentiment of the new rebirth of democracy here in this state and across so many in the South during that exact same period for people who had so long been denied that right as well as basic citizenship. And the forces driving in support of this education clause were unstoppable and for all intents and purposes unopposed. The words they chose were simple. The legislature shall provide, by general law, for a thorough and efficient system of free schools. These words are crucially important, yet so often escape our modern-day attention. They don't smack of the glory of liberty or freedom or anything of that sort, but their design was no less audacious. Each of the words in this clause is crucially important. I retread some of what you heard this morning. But the first part, the legislature shall provide. Not mom, not dad, not the church, not the local school district, not your uncle, not your aunt, not your best friend. The state shall provide. A thorough and efficient, not random, not the best you can do, not what works here or there, not what local sentiment will tolerate, thorough and efficient. System, not education for one type of education for the north part of West Virginia, another for the south, another for the east, another for the west. No, a system of education from the top to the bottom from the east to the west, a system of education. And as Zoe said this morning, a free education. Not an education that included tuition, not an education you had to work for, not one for those who could afford to pay, a free education for all. When Zoe spoke about it this morning, there was one thing that is Zoe still here? No? One thing she missed, and partly because of the early period in which West Virginia passed its constitution in the early 1600s, by the end of the Civil War, it said free education for all. All the other southern states say free education for all. And that was a clear response to the fact that poor whites, and even more importantly, African Americans, had been denied that opportunity. A free education for all. These phrases in the West Virginia Constitution are not unique, they are not isolated. They pop up in a number of other states, and they represent the culmination of a half a century of debate during the early 1800s. A debate about whose responsibility it would be to provide education. A debate about who would finance education. A debate about how education would be run. This clause represented a response to the paucity of educational opportunity in so many places. And it also represented, in many respects, the zeitgeist of this period for both poor whites and the newly freed slaves. Speaking of the working and farmer class, Horace Mann proclaimed in the decades prior to the war, that free education is as much a part of the birthright of parents' offspring as heaven's bounties of light and air. That free education is a birthright as much as the bounties of light and air. W.C. Garnett, a student of Horace Mann who spent 3 years with the freedmen during the Civil War, reported from Savannah, Georgia on April 28, 1865. He wrote, quote, "The freedmen here betook themselves to education with speed and energy. It was their first act on coming to the surface, a kind of instinctive head shaking and clearing of the eyes after emerging from the waters. Of all the things the freedmen could have done with their time, with their breath, with their labor, their first breath was the breath of education following freedom." And so too was it for West Virginia. Coming up from the waters of the Confederacy, West Virginia takes its first breath of constitutional air and does not delay. It declares, I read to you again, the legislature shall provide by general law for thorough and efficient system of free schools. This idea, like so many other great ones of this period, unfortunately gets buried. It takes nearly a century for it to resurface. And by then, quite a bit of dirt lays upon it when the West Virginia Supreme Court comes back. Notwithstanding, I think, some decent Supreme Court analysis, there was not much good precedent to support what the West Virginia Supreme Court was about to do. There certainly was no good federal precedent. The court had said that education is not a fundamental right under the federal Constitution, and if you read San Antonio versus Rodriguez, you would think that education was no different than the bus ticket that the local municipal authorities might hand out to poor people. There were no established qualitative guide rails for that court. There were no Rose factors from Kentucky. There were no CFE input-output analysis from New York. There was no Abbott v. Burke and adequacy. It was just the West Virginia Supreme Court. And it nonetheless pressed forward. The basic holding is quick and without fanfare, but with enormous depth, declaring, as I said earlier, that education is a fundamental right in the state of West Virginia. But equally important, it is the duty of the state to provide for that fundamental right. The court wrote, "Our basic law makes education funding second in priority only to the payment of the state's debt and ahead of every other state function. Our Constitution manifests throughout the people's clear mandate to the legislature that public education is a prime function of our state government. We must not allow that command to go unheeded." And when the state fails in that respect, or someone fails in that respect, we shall apply strict scrutiny, the court said. Because education is a fundamental constitutional right in this state, under our equal protection guarantees, any discriminatory classification, not just racial, any discriminatory classification found in the education financing system cannot stand unless the state can demonstrate some compelling state interest to justify the unequal classification. And finally, that decision in Pauley asked that this state perfect the system of public education. Reading from the Ohio Constitutional Convention, from whom it had borrowed its own constitutional language, the West Virginia Supreme Court recounts the statements from Ohio's convention. They, quote, "wanted to see a system of schools as perfect as could be devised, and to see it improve so as to keep pace with the most rapid progress of the most rapid element of our social or political constitution." This, the West Virginia Supreme Court says, tells us what a thorough and efficient system should attain. These ideas are so powerful and encompassing that West Virginia became one of the few states to make good on them, at least as a matter of doctrine. It did not leave the fundamental right to education at the issue of school funding. It applied it to other issues that came before it. Most notably to me is school discipline. In Philip Leon versus Greenbrier in 1996, West Virginia once again stood out amongst its peers. In the context of school expulsion, West Virginia Supreme Court did not shirk from that Constitution, did not make excuses for that Constitution, did not make exceptions to that Constitution, but simply recognized that education was a fundamental right and that, again, incursions on it would warrant strict scrutiny. The court, in justifying itself, said of these children to be expelled, "Without alternative education, children similar to JPM become orphans, abandoned by the education system, without anyone to educate them and give them the opportunities inherent in being an educated person. If the West Virginia Constitution makes education a fundamental right, then children similar to JPM must be afforded an education and services. JPM and other similar children are not orphans of the education system, because the West Virginia Constitution bars their abandonment unless the state can demonstrate a compelling interest." So many other states, in fact almost all other states, have refused to take that step in the context of school discipline. So the problem since Pauley, I would say, in other cases, is that we have not taken these original intents of the framers and the more precise holdings of these cases seriously enough. We don't sue when we should. That's for you, David. You like that one. We don't sue when we should. David always sues. The rest of us don't. We don't sue when we should. We look the other way when someone wants to experiment with our education system. We don't always make sure education is the top priority each and every year. And sometimes we know exactly what Pauley requires. We know exactly what the Florida Constitution or the New Jersey Constitution requires. And people try their darndest to get around it. In Florida, after the Supreme Court said in Bush v. Holmes, the Constitutional Common School Fund is for the state's common schools. You cannot spend it on vouchers. The state devises some other convoluted tax and incentive program that we just simply call education savings accounts. When states like Texas's Supreme Court demand adequate and equal funding, their legislature says we'll provide adequate and equal funding, and we'll cover special education costs for all the districts in the state. But we won't cover it for any more than 8.5% of the students being special ed, even though 13% of the kids nationally are special ed students. And Texas says we're just going to cap it at 8.5. Right? Any number of more complex games that they play. Virginia cut out $339 million, simply saying, well, we're only going to cover this many personnel per classroom. We ignore Polly, we ignore its intent, we ignore the framers when we ignore the implications of charter schools. Only the Washington Supreme Court has been brave enough to say public school funds in the Constitution's Common School Fund are for the state's common schools. California, exact same language, comes up with convoluted analysis as to why the state should be allowed to experiment, as to why common school funds can be spent on charter schools, a new invention. And California, by the way, is a state where education has been declared to be a fundamental right. No surprise that teachers went on strike over charters in California recently. No surprise that teachers left again and went on strike here in West Virginia. The question for us, it seems to me, is whether we will honor or dishonor our fundamental commitments and ideas. We have failed so many times over the past century and longer, but it's not our failures that should define us, it is our aspirations. Our founders articulated national goals and ideas in the Declaration of Independence and in the federal Constitution and the various state constitutions, not with any certainty that by writing those words down, that the ideas would spring into reality simply because they were on paper. They wrote them down in hope that we might one day live up to those words. And the fact that we may have still yet to live up to those documents has never been a reason to dismiss or minimize those ideas. When the Declaration of Independence announced in 1776 that all men are created equal and endowed with inalienable rights, it didn't make a single man, much less a single woman, much less an African American, free or equal. But those words remained a fundamental idea that would inspire a president, that would define a war effort, and demand constitutional amendments a century later in places like West Virginia, South Carolina, Mississippi, Alabama. Abraham Lincoln, prior to becoming president, would say, let us readopt the Declaration of Independence, and with it, the practices and policies that are necessary to harmonize with them. He understood that our foundational documents may ask more of us than we can reasonably bear in the moment we write them down on paper. But if those ideas are just, they will endure. They will propel future generations towards a higher reality than the drafters themselves ever could have first imagined. When the founders declared all men equal, Lincoln said they knew it was not the case that all men were enjoying that equality. Rather, they meant to set up a standard maxim for free society, constantly looked to, constantly labored for, and even though never perfectly attained, constantly approximated, and thereby constantly spreading and deepening its influence. Speaking in Lewistown, Illinois in 1858, Lincoln expanded even further on this simple idea, saying that it mattered not that those who issued the Declaration of Independence refused to extend its self-evident truths on life, liberty, and the pursuit of happiness to the whole great family of man. Because when they uttered those truths, when they wrote them down, they reached forward and seized upon the farthest posterity. They erected a beacon to guide their children and their children's children and the countless myriads who should inhabit the earth in other ages. Wise statesmen as they were, they established these great self-evident truths that when in some distant future, some man, some faction, some interest should set up the doctrine that none but the rich man or none but the white man were entitled to life, liberty, or the pursuit of happiness, that posterity might look up again to the Declaration of Independence and take courage to renew the battle which their fathers began, so that truth, justice, and mercy, and all the humane and Christian values might not be extinguished from the land, so that no man would hereafter dare to limit and circumscribe the great principles upon which the Temple of Liberty was being built. In the Gettysburg Address, he went yet one step further. We are engaged in a great civil war, testing whether that nation or any nation so conceived and so dedicated can long endure. And what we see in today's legislative refusal to respect our public education systems, to trade them for charter schools, or weird doctrines and convolutions and funding formulas that Lincoln spoke of, these are the tests that call on us to revisit, to recommit, to rely on those original ideas. They raise the question of whether a Republican form of government that commits to public education for all its children shall endure as first envisioned or fade into some lesser form today. So when some faction or group should tell us that only some children should go to public school while others might try vouchers or charters, so when some faction or group should tell us that only some public schools should have adequate and vast resources, so when some faction or group should tell us that only some schools can hire quality teachers, handle the most rigorous curriculum, graduate students fully prepared for college, the posterities of our founders, the posterity of Polly, must rise up and beat them back. To say that those are not the ideas upon which we have built this Republican form of government. Those are not the ideas upon which we have built this democracy. They are not the ideas upon which a fundamental right to education exists. And they are not policies that our constitutions will tolerate. We must take those ideas so seriously that we will fight for them in the courtroom, we will fight for them in the school board room, we will fight for them in the halls of the legislature, and ultimately, if necessary, in the streets of protest surrounding those buildings. Thank you. So obviously I see it that way and I don't need to take any questions. But I'll at least entertain your thoughts otherwise, if you have any. Any questions, comments? John? Yeah, I mean, I will say that it was. Well, no, in 2009 or so, I said, ultimately, the train on charter schools has left the station, except for in a couple of places, and you can't just sit over here and whine in the corner about how you hate them. And also, I do believe that charters are an empty vessel. They don't actually, from my perspective, they could be anything we want them to be. They could function within a system if we wanted to. They could be equal and open and do great things if we wanted them to be that. I think my error in that respect is probably naivete, which is I may have saw them as an empty vessel that we could have a reasoned conversation, a reasoned management, a reasoned control about. What I did not appreciate was that the real people who wanted them didn't want to have reasoned conversation, that they were not empty vessels, that actually they are an ideology markets as opposed to that empty vessel. And so I think, I can't speak for others, but I think the sort of naivete about what they really represented has sort of worn away at this point. And the idea that somehow or other we could corral them and make them something that could work is difficult to imagine, because the people who would ultimately run them and are pushing for them want them to be something far different than the empty vessel that I might see them as a place that maybe we could, create special opportunities. Maybe we could create more diverse schools. Maybe we could break down school district boundaries in a way that served, broader communities. That is not, at least in my estimation, what 95% of them represent. So I think that cold, hard reality is what has driven the sort of opposition to them, at least in my estimation. Others? Yeah.
Thank you so much for being here. You were talking about how we are too hesitant to sue, and sometimes we need to when the legislature or someone else is obviously flagrantly ignoring precedent or constitutional norms. We need to step in. I've had a lot of conversations with folks in West Virginia who are worried that poly may be really great precedent, and now may not be the time to try to come in and reinforce parts of poly. So maybe not specific to West Virginia, but do you have thoughts on that kind of strategy when it comes to this type of important litigation?
Yeah, I mean, I have the exact same fear in South Carolina that if I were to wind up before the state Supreme Court, that Abbeville versus State would disappear before my eyes. I think the question is a right, and Josh and I have spoken a lot about this, and I wrote a little bit about it. I mean, what is the good of a right that isn't enforced? I mean, is it a right at all? And so what we're really doing is fighting to maintain the memory of what we thought poly was rather than sort of maintaining it. That's probably an overstatement, though, because courts changes, and maybe you wait. I think my point and my remarks are, if we, as a people or as a community, really believe that poly was right, that the Constitution represents those ideas, then we ought not fear, because we stand on the side of posterity. We stand on the right side of history. And if there are some that would impede us for a while, so be it. But if they don't think we're serious, then they have no inhibitions about introducing any number of policies into state law, because no one will call them on it. No one will call them on it, right? And it seems to me that embedded in part of my talk is the idea that somehow or other education is just a policy prerogative that legislators think they can do whatever they want to. Now, I'm the first to admit they have enormous discretion, but there are clear boundary lines. And the problem is a lot of them don't think that they have clear boundary lines. They think that because they have been elected by a majority of people in some community, that actually elevates them above the Constitution, right? They find it offensive that somehow or another their discretion should be restrained. And to that response, I say that, yes, it is true that tyrants, it is true that tyrants can be elected to office and take office. Tyrants can believe in their own tyranny. But the fact that a majority of people elected someone to be a tyrant does not give them the authority to act as a tyrant in that position. And so to me, that sort of constant pressure that ultimately there is a Constitution here that constrains you at the edges is important, because if they don't have that, ultimately they do whatever they want to do. And I mean, I think Washington is a perfect example. I mean, it was pretty crystal clear that what they were doing with their charter school law there was unconstitutional, but somehow they just thought they would do it anyway, right? I mean, it is amazing that, and maybe it's, because they don't have to listen to Josh and I, lecture them. They're out in the free world and can think whatever they want to. But ultimately, they operate on a blank slate every legislative session. And they think, or at least I should say, they think they operate on a blank slate, when ultimately they must act within a constitutional system. I mean, that's hard work, but I think that ultimately we have to be serious, because if we're not serious, they're certainly not going to be serious. Yeah. Yes. Yes.
I was curious if you could speak to education federalism issues within the context of substantive rights. That is, I'm really interested to hear your views on the role of the federal block grant power moving forward.
Well, I mean, ultimately, you know, Congress can spend its money on whatever it wants to, and states can say yes or no to it. So I don't really think that is so much an issue of federalism. But I guess, you know, maybe implicit in what you're asking. Well, I don't know if it's implicit, but I mean, I think we have broader questions, not about whether Congress can, to what extent Congress can help and support states, but to what extent can they dictate. And I don't, at risk of putting folks to sleep, I don't want to get into the four prongs of South Dakota versus Dole today, or Sebelius versus NFIB and coercion. But you know, ultimately, I do think there are limits to what Congress can demand in exchange for the money, or at least how they demand it. And I think that Arne Duncan made an enormous mistake during the Obama administration, and I wrote an article about it, that I think that they imposed through No Child Left Behind waivers, and also through Race to the Top, a set of conditions that I argued the Secretary didn't have the authority to make, but Mott made right. I think actually those may have gotten struck down eventually, but the Every Student Succeeds Act was replaced those waivers before, and it made the litigation moot. But so I do think the federal government has to be careful about what it's asking for in exchange. But you know, ultimately, if they're willing to spend the money on it and the states are willing to accept it, I don't see there's any limit. You know, maybe the question is that a good idea? You know, for them to be doing that. I tend to think that we have really good standards of adequacy and equity developed through the state constitutional decisions, and that all of this, or most of the nonsense that comes out of the Department of Education is, you know, econometrics and the business lobby, not sort of about adequacy and equity. You know, give the states more money to support them with complying with the adequacy and equity standards that we've been developing. Give them the money they need to determine, you know, cost study and what's this child need versus what that child needs. This sort of idea that we need a new rubric for, you know, career and college ready, and again, notwithstanding what the governor had to say, the idea that we need a new rubric every 10 or so years just leads to sort of this like constant sort of churn of reform that I don't really think does our children much good. But other questions? Well, thank you for indulging me, and I won't separate you from the rest of your meals, and look forward to seeing you this afternoon. Thank you.